Good afternoon, Law Club brothers and sisters. Good to see some of the faces out there. I'm still looking forward to
You just went mute, Pete.
Thank you, Ronald. I'll start again. Good morning, Law Club brothers and sisters. Great to see some of the faces on here. It's good to see that Ted Blanford hadn't shaved in a while, and a few of you other folks we haven't seen in a good bit of time. Looking forward to hopefully being back together in the fall. I've commented before that our population is an older population, which means maybe a larger group of us have gotten that first or second vaccine. So for once, it's kind of good to be older. Next month, one of our own, John Pachter, is going to be speaking to us. John does a lot of plaintiffs' legal malpractice work. Susie said to remind everybody that will qualify as your CLE ethics for the year. So for those of you that need another hour of CLE ethics, you can get it by attending next month. John's topic will be ethical concerns and risks related to boilerplate clauses in many documents we do just kind of perfunctorily. I think John will probably make us sweat a little bit in a good way. So I look forward to hearing what John has to say to us next month. I'm going to give the floor to Ron and Brad, and I have to get off about 5 minutes before this is over to start a mediation at 1. So they're going to call the show at the end of the day. But thank you, gentlemen. You have the floor. And this is a reminder to everybody else, please mute. Thank you very much.
Thank you, Pete. And obviously it's a pleasure once again to address the members of the club. I'm looking forward to when we can do it in person as well. And Pete mentioned the vaccines. Actually, I'm getting the second dose of mine today. So I hope to enter the real world with other people in the not too distant future. But today we're doing it virtually, and we've got some very interesting cases to talk about. But before we do, as I often do at the beginning of these, I identify with something in the news that I thought you might find of interest. And the item of interest that I saw was a piece, I saw it in the ABAjournal.com, but it apparently originated in the Louisville Courier-Journal and some other places.
Starts to veer into a lesson I learned very early on. And once
Okay, we've got, all right. Okay, I think we're back. I'm the one that's being heard by everybody, I hope. So what this article basically spoke to was the perils of Zoom hearings. And I think most everybody probably saw the clip of the lawyer who appeared as a kitten during a Zoom hearing. And what the Louisville Courier-Journal is, they went out and investigated in Kentucky what other kinds of embarrassing incidents may have occurred that might be of interest. And they found that in Kentucky, there was a lawyer who fell asleep and began snoring during the virtual hearing that the judge could see. They also observed that during one of these hearings, one of the speakers, and apparently it wasn't directly identified, was heard complaining, "This is effing stupid," apparently in response to something the judge had said, which probably is something that the judge wouldn't hear in the ordinary course. And then there were incidents involving a lawyer drinking a glass of wine during a hearing about a parent's problem drinking, and a couple of cases involving issues of the undress of persons on the screen during the Zoom hearing, one involving a naked lady who just appeared but didn't seem to have anything to do with the case, another involving a woman who wasn't wearing clothes, had curlers in her hair, and apparently was unaware her camera was turned on, and a defendant who appeared without any pants on. So those are things obviously that don't occur in the pre-Zoom world, but they occurred now. But the ones that I thought were of most consequence were of the defendant, who on the Zoom hearing appeared apparently at his home with a meth pipe visible on a table behind him, which was probably not a good sign for his defense in the case. And another instance where a party, a client who had been in a car accident, decided that she would do her deposition on Zoom while she was driving. I guess, obviously, we are accustomed before going to hearings to advising our clients to get ready and be prepared. It looks like in the Zoom environment, we've got to prepare them for a lot more than essentially what they're going to wear, but what's going to be in the screen behind them and what they should be doing while they're doing something like a deposition. So those I thought were of interest, but what's of most interest, I know, to all of you are the recent cases from the Indiana appellate courts that may affect your practice. And we're going to start this morning with two cases from the Indiana Supreme Court decided last month, both decisions by Chief Judge Loretta Rush. The first was the case of Doe versus Carmel Operator LLC. It involves an interesting question of when an arbitration can be compelled in accordance with an arbitration clause in a contract to which the party who is being sued is not in fact a party to the contract. So a non-party to the contract. And the issue arose in this context. You have a lady, age 77, Jane Doe II, who has moved into an assisted living facility, the Carmel Senior Living. And her legal guardian pays the deposit and signs a contract on her behalf, a contract with an arbitration clause. Several months thereafter, suit is brought by the guardian on behalf of Jane, alleging that Jane had been sexually abused by an employee who had prior felony convictions for a sex crime and a murder. And the guardian had sued first the Carmel Senior Living, the company, second, the management company that ran the senior living facility, third, the employee who was responsible for the sexual assault, a man named Sullivan, and fourth, the company that Carmel Senior Living had hired to run background checks on new employees, a company called Certify Screening. And then an issue is whether this entire case had to be arbitrated or not. And there was no significant issue that with respect to Carmel Senior Living, its management company, and its employee, all of those were clearly covered by the arbitration clause in the contract. What was not clear was whether this company hired to run background checks, Certify Screening, would also be a dispute that had to be arbitrated. So the certified argued that it should be applied to them based on theories of agency and equitable estoppel. And if Certify was in fact an agent, then they would be protected. But the Supreme Court, when looking at it, said no. An agency requires, among other things, control exerted by the principal over the agent. And in this case, there was no evidence that CSL or Carmel Senior Living asserted or exerted control over the agent. So this agency failed. The second theory was one of equitable estoppel. And that's the one that's been used frequently in these cases to bring non-parties into arbitrations. And the court said, well, there are certain things where federal law comes into play with respect to arbitration, but that simply basically deals with the scope. But when we're interpreting the contract that provides for arbitration, that brings in the Indiana law of contract. And with respect to an Indiana law with respect to equitable estoppel. And the court said, you cannot have equitable estoppel unless there is reliance upon the conduct of the party to be estopped. And that reliance causes a prejudicial change in position. And the court said, there's no evidence of that here. The traditional elements of equitable estoppel are not satisfied. And so we're not going to enforce the arbitration clause as to certify based on that. But that didn't end the inquiry, because there had developed over a period of time in federal courts and in the Indiana Court of Appeals the notion of alternative equitable estoppel theories that would allow for arbitration in this kind of a situation. The Supreme Court looked at those alternative equitable estoppel theories and said, when we look at them, they seem to be based more on judicial efficiency than equity. And the court, at the end of the day, says, we're not going to apply any of those here in Indiana. They may apply them in federal court, but that's not going to be the law in Indiana. And the court did so, saying to force signatories to arbitrate clauses they did not agree to arbitrate would unfairly deny them their rightful access to the courts. And so at the end of the day, the court says, you're going to have to qualify as an agent, or you're going to have to qualify under traditional principles of equitable estoppel if you're not actually a party to the contract. And here, certified didn't qualify, and that's a matter that's going to go to court. It's not going to arbitration. So significant decision in terms of how arbitration is going to be applied to non-parties on a going forward basis. The second of those Supreme Court cases from last month that I said I was going to talk about involves the valuation of shares owned by a minority shareholder. In the case is Hartman versus Big Inch Fabricators and Construction Holding Company. Now, for those of you who pay close attention to these presentations and remember the presentation that Brad and I made last July, actually, I was speaking, I believe at the time, from South Carolina, from Kiowa Island. And I spoke of a case decision by the Indiana Court of Appeals, which addressed this issue and it made significant new law at the time. And if you have those recollections of what we said at the time, let me simply say, reminiscent of Gilda Ragnar, never mind. That's no longer going to be the law. The Indiana Supreme Court has established significant new law in this area in the case of Hartman versus Big Inch Fabricators, where the Court of Appeals had previously ruled. And what the court did, it looked first at this situation where you had Hartman, the plaintiff here. He'd been an officer, a director, and a shareholder in Big Inch Fabricators and Construction Holding Company. His fellow shareholders decided that he should be terminated, which he was, which brought into play a buyback provision in the shareholder agreement. The buyback clause said that Big Inch, the company, would repurchase the shareholder's interest if the company involuntarily terminates the shareholder as an officer or director. So it comes into play. And it provided that the company must pay the shares appraised market value as determined by a third-party valuation company in accordance with generally accepted accounting principles. And this then raised the question, well, actually it raised the question first because Big Inch, after terminating Mr. Hartman, did get an appraiser, hired an appraiser to value Hartman's interest. And when he did so, the appraiser discounted the shares on two bases. One, for their lack of marketability, and second, for Hartman's lack of control. And based on those two discounts, arrived at a valuation that Hartman disagreed with. And he sued Big Inch, saying those discounts should not have been applied. And he persuaded the Court of Appeals of that, but not the Supreme Court. They said, given the language of this particular shareholder agreement, the buyback clause, which required that the price be at the appraised market value is assessed based on a look at the value the shares would have on an open market. Now, we're dealing with in the context of a compulsory sale to the company, but the court said, but the agreement as to value was the appraised market value. That means considering the open market, and that means if there are discounts in the open market, then those need to be applied, specifically the discounts associated with lack of control or a non-controlled position, non-controlling shares, and the fact that there isn't really an open market for them. These are compulsory. And so the court said, given the language of this particular agreement, that it was appropriate and I'm not certain that it says they have to be applied, but clearly it said it could be applied in determining fair market value. And we have only in this case one appraised fair market value by an appraiser using generally accepted accounting principles. And the court said, given that evidence, Big Inch wins. Mr. Hartman's, these discounts are applied and the value of his shares go down by, I think, about 1.2 million in this case. So I guess the big lesson at the end of the day is if you're in this kind of a situation, be sure you get your own appraisal. Don't simply go to the court where you've got the only appraisal being that of the company, which and the company's appraiser, who is clearly going to give full value to these discounts and the reduced value to the minority shareholder. So with that, I'm going to turn it over to Brad, assuming he's still with us.
I am. And the first two cases I'm going to talk about both deal with the Home Improvement Contracts Act, which was an act by the General Assembly to protect homeowners against what was seen as unfair and deceptive practices by contractors. And the first case is Kluger versus JJP Enterprises, Inc. Now, JJP was going by the name of ServPro. So that's what the opinion called it. And that's what I'm going to call it. And what happened in this case is you had a tornado come along and tore the roof off the Kluger's home. They filed a claim with their insurer, and the insurer hired ServPro to do the cleanup and restoration work. Well, ServPro met with the Klugers, presented a contract on an iPad. Mr. Kluger said it was too bright apparently to see what it said. The employee pointed to where he needed to sign. He signed it, and so he didn't really read it. And it turns out this contract did not provide many of the things that the HICA, this Home Improvement Contract Act, requires, like a description of the work to be done, estimated cost, and an estimated date of completion. Well, ServPro did some cleanup work, but didn't cover the home with a tarp after it did that initial cleanup. Well, a few days after that initial cleanup, some heavy rain came. And so when ServPro didn't provide any water extraction services on either the home or the belongings of the home. And then later, ServPro didn't send a bill to the Klugers and explained that, well, you know, this project had slipped through the cracks, so that's why they're not billing. That turned out to be important for ServPro's argument, as we'll see later on, because the Klugers sued ServPro and for not having a salvageable home and HICA violations, and ServPro filed a counterclaim asserting it was owed about $8,000 for the services it had provided. Well, the Klugers moved for summary judgment, and ServPro defended against that, saying that the statute did not apply because there is a de minimis threshold before it applies of $150. So the contract price is $150 or below, the statute doesn't apply. And it says, well, we never billed them anything, so the statute doesn't apply. The trial court agreed with ServPro and denied the Klugers' motion. So the Klugers amended the complaint to assert claims under the Indiana Deceptive Consumer Sales Act, because a HICA violation is a violation of that statute too. And at this point, ServPro did not reassert its claim for $8,000. And so when the Klugers again moved for summary judgment, ServPro again argued this de minimis threshold wasn't met, and the trial court again agreed with ServPro. So the Klugers appealed. And on appeal, the court said that ServPro's argument was mistaken, that while ServPro and the trial court may have thought that the definition of contract price, which is like how this $150 de minimis exception was defined, well, they meant the amount of the invoice, but the court said, no, that doesn't make any sense, because under the statute, the contract itself is supposed to say what the contract price is. And so you need to have that initially, not what is later billed. And that, in most cases, the agreed upon contract price is going to be prior to the commencement of work at the time the contract is executed, not later on. And so the court said that what is readily apparent is that when a statute talks about contract price, it contemplates the price at the beginning of the contract, not what the contractor eventually decides to bill. And this is what the court really thought about Servpro's argument, is because Servpro had already violated HICA when it commenced work, it cannot evade potential liability by simply withdrawing its demand for payment during litigation. To do so would undermine HICA's broad remedial and deterrent purposes. Therefore, the trial court erred when it denied Kluger's motion for summary judgment, and it went back down to continue additional litigation. And then this next case is somewhat related because it also deals with HICA, and it deals with a contractor's attempt to get around some of its provisions. And this is McGraw Property Solutions, LLC versus Jenkins, which was decided just a few weeks last fall after the prior case was decided. And the issue in this case is you had HICA violations. Under that Deceptive Consumer Sales Act, this is something that could be cured. And so the question is, does the cure relate back or not? Let me give you that's the legal context. Let me give you the facts. Jenkins owned a home that was damaged by a severe storm and hired McGraw to do storm remediation. Now, the contract that he signed said that Jenkins would pay 20% of the replacement cost as liquidated damages if he decided to cancel the contract with McGraw. The McGraw estimated the total replacement cost was $170,000. So that's a significant amount of money that as liquidated damages. Well, Jenkins decided eventually he wasn't going to get the work done. He was going to move to Florida instead. So McGraw sued him in August of 2017. And Jenkins, in response, sent McGraw notice of violation under HICA, alleging a number of things that weren't in the contract, including a statutory right to cancel the contract within 3 days. So McGraw sent a replacement contract that cured all these defects, including that statutory right to cancel. And so Jenkins signed the contract and sent a notice of cancellation the same day. So the parties then filed cross motions for summary judgment on whether he was have to pay these liquidated damages. And the trial court found against McGraw, finding that Jenkins properly exercised his rights under this new contract, and McGraw appealed. And on appeal, McGraw said that this is absurd because this is just boilerplate language that gives the homeowners an upper hand here whenever this immaterial boilerplate language is omitted from a contract. But the court did not appreciate that. It said it is irrelevant whether the language that was omitted from the contract was boilerplate or important, as soon as one of the statutorily enumerated requirements is not included in the contract. A deceptive act has occurred and the contract is in violation of HICA, regardless of any intent by McGraw. And it found that if you have what McGraw wanted, that new contract relates back timing wise to the first one on that 3-day cancellation period. That renders the 3-day period meaningless and does not cure the original contract because the main focus of the right to cure is to remedy the deficiencies of the original contract and to give Jenkins the rights he was not originally given. And so those cures become meaningless if it's impossible for him to exercise those rights. Now, importantly, this doesn't mean an end to the litigation because the court found there still might be an unjust enrichment claim that McGraw had alleged that it could recover under. And so it did mean, though, that $34,000 that McGraw was trying to get as liquidated damages were no longer available to it. Ron?
Our next case is McLean versus Trissler, decided by the Court of Appeals on December 10th, and also involves issues concerning damages and what's required to prove damages. And it does so in a pretty interesting context involving a lot of very improper conduct by the defendants, at least as it's reported in this case. The issues arise in this context. You have two men, Trissler and Keppen, who open a Greek's Pizza at a pizza shop in Carmel in 2014. And they open an LLC, created LLC called GMRT. And then they bring in a third party to this business. They get $90,000 from McLean, and he's to share in the business. And he's starting with 30% of the business. Keppen has 45%, and Trissler 25%. There appears to be no operating agreement at that point in time, but Keppen leaves the business, and his shares are divided pro rata between Trissler and McLean. So McLean now becomes the majority shareholder, or the majority owner of this LLC. And though he is the majority owner, there's some other things that start happening. One of which is Trissler decides he wants to buy another Greek's Pizza, and he does so by taking funds from GMRT, apparently without McLean's knowledge. And Keppen, although he's no longer in the business at all, he decides to take funds to help make some payments on a personal loan. So you've got things that, by all appearances, appear to be conversion of assets of the LLC, of which McLean is the majority owner. And he becomes concerned about business. He asks to review the books. Trissler doesn't comply. Apparently, he's the one actively controlling these things. And he also tells McLean that there's no operating agreement. However, as the events evolve, McLean then produces what he says is an operating agreement, and it purports to have McLean's signature on it. But according to this opinion, it's established that the signature of McLean on this operating agreement has been forged. So we've got conversion, a couple of conversions, and now some forgery by these defendants, according to the facts as reported. And then Trissler decides to go ahead and sell this company, although he's a minority owner. He sells it and keeps all the money. Nothing goes to McLean from this sale. So McLean sues Trissler and Keppen and other entities that they're associated with. And he sues on theories of both a derivative shareholder claim, that is on behalf of the corporation. Generally, if there's conversion of corporate funds or business entities funds, it goes back to the corporation. And so it may be a derivative claim, or it may be a direct claim. At the end of the day here, the court says this qualifies as one where McLean has a direct cause of action. There are circumstances in which, although it would ordinarily be a shareholder derivative claim, if it's a closely held corporation, and if it's one where the what might otherwise be corporate damages, there may be a direct claim if it would not unfairly expose the corporation or the defendants to a multiplicity of actions, where it would not materially prejudice the interests of creditors of the corporation, and where it would not interfere with a fair distribution of the recovery among all interested persons. And the court said, we're going to let, under these circumstances, McLean assert these as direct claims. And as it turns out, the misconduct of these defendants continued during the litigation. They engaged in what the trial court said was discovery misconduct. Discovery, in fact, misconduct that included not responding to interrogatories, amending the interrogatory and answering the question that they preferred to answer. McLean moved for sanctions for this discovery misconduct. The court granted the motion, and as a sanction for the motion, awarded final judgment to McLean on liability against all defendants and set the matter for a damages hearing. So now you've got McLean seems to be on the way to winning this thing. He's got a sanction for, essentially a default judgment on liability. Now the question is damages. So there's a damages hearing and damages discovery, but defendants engage in further misconduct, according to the court, in not cooperating with damages related discovery. A motion to compel is filed and further sanctions are imposed and awarded by the court. McLean requests about $21,000 in fees associated with these sanctions, but the trial court does not immediately rule on that. Instead, there's a damages hearing. McLean testifies about these withdrawals from the LLC's bank accounts. He says he objected to the sale of the business and hadn't received any of the proceeds. And there's something of a mess, apparently, at the time of this hearing. Apparently, the trial judge throws up its hands and says, I don't think you've proven your damages here. And so I'm essentially awarding, denying all pending motions and denies any relief to McLean in these circumstances. McLean, of course, appeals. And there are some preliminary arguments and issues that are raised, but the ones I want to get to is whether McLean had proved his damages with sufficient certainty. Trial court apparently determined that he hadn't. The Court of Appeals said yes. If there is uncertainty, any problems there are to be resolved in favor, is not to be resolved in favor of the wrongdoers. It's to be resolved in favor of the claimant. And here, there was evidence that the business was sold, that he owned more than 50% of the interest. He should have gotten at least 50% of the $350,000 that it was sold for. That's a clear damage that he's available to him. The money that was taken out of the business for the other owner's interest were also improper and were clearly defined. And the court said, yes, that's sufficient, and commented that no particular degree of certainty is required in awarding damages so long as the amount awarded is supported by evidence and not based merely on speculation or conjecture. By the way, one of the other sanctions was the defendants could not introduce any evidence to the contrary. They were not allowed to present contrary evidence. So, and then of course, in deciding the case and saying, yes, there's sufficient evidence here of damages, the court also said, just because the trial court determines ultimately in favor of these defendants, that does not mean the sanctions are not enforceable, and the sanctions should have been awarded, and specifically awards them on appeal. But the court even actually went beyond that on appeal, given this history of misconduct. They suggested that when they remanded the case to the trial court for further proceedings, that the court also consider damages under the Crime Victims Relief Act, so that Mr. McLean might get treble damages plus additional attorney's fees, which were not apparently at issue during the first trial. So that's I guess in terms of what's the lessons going forward, more than anything, it is if there's uncertainty about damages and you've got clear wrongdoing, at least the Court of Appeals is going to have a pretty low standard in terms of proving certainty of the damages associated with the misconduct. And it's also clear that they do not like this course of conduct that occurred here by these defendants and their litigation misconduct. So obviously, none of us would want to engage in that sort of misconduct. So let's move on to the next one, which also includes a consideration of damages. In this case, the Renner versus Shepard Bazant case, there was in fact a default judgment issued, and it arose in this context. Actually, it's a car crash case involving a rear end collision, but it has some preceding events that affect the damages. And specifically, the events were as follows. The plaintiff, a young woman named Renner, was 18 years old when this accident occurred. She had been a cheerleader and a good student at her high school and had suffered 2 concussions previously to this accident. One when she fell from a swing set and suffered a concussion about 5 years earlier, and another when she fell during a cheerleading routine. So before this rear end collision, she's had 2 concussions. And the evidence was that if you've got some concussions, it's more likely you're going to suffer future concussions and more severe symptoms. And when she was rear-ended by a fellow high school student by the name of Shepard Desant, she started getting much more severe symptoms. But shortly after the accident, other things happened that complicated the situation. We not only have before incidents, there's after incidents, including I think 3 days afterwards. She was advised that given the serious concussion, she should not go to the prom, but she went to her senior prom. She had a trip to an amusement park scheduled the next day, and she rode the roller coasters with her friends, and that resulted in more severe headaches, etc. And then that summer, after all of these, she lost her balance and hit her head on a doorknob, and then was roughhousing with her brothers, both of which events also caused more complications. So the issue is, can we separate all these other events in terms of assessing the damages to her? And the court started with, what about these prior events, these prior concussions? The trial court, when it considered it, said, well, this is somebody who already has significant problems, and those the trial court used to discount her recovery. In the trial court, she had asked for over $600,000 in damages, and I won't go into the details, but she had significant complications thereafter in terms of headaches, in terms of her ability to concentrate, in terms of her ability to do her studies. It significantly affected her life. So she asked for 600,000 plus. The trial court awarded her 132,000. And in doing so, it basically discounted, saying, well, she already had 2 prior concussions, as if those should reduce the damages. The Court of Appeals said, no, that's not the way it works here. If you have an eggshell plaintiff, and in this case, you've got an eggshell plaintiff, or what it refers to as the eggshell skull rule. If you've got somebody who is especially vulnerable because of prior incidents, that means when you do the 3rd concussion, it's not because you don't discount for it. She's in a more vulnerable position, and you're going to be responsible for all the damages associated with that 3rd concussion. It's not reduced by the fact that she had 2 prior incidents. Court also said, with respect to the subsequent events, there was no evidence that those contributed in a material way to her problems. They did talk about mitigation of harm. Now, obviously, all plaintiffs have a duty to mitigate their damages. But the court made clear that this failure to mitigate defense does not apply unless the defendant can show, quote, a discrete harm separate from the effects of the auto accident. So a discrete harm separate from the effects of the auto accident. And the court looked at the evidence presented by the defendant here and said, that didn't meet that standard. Big lesson, though, is a defendant takes his victim as he finds them. The eggshell skull rule, it applies in Indiana, and so prior concussions making a person more vulnerable is not going to result in a reduction in the damages, and a failure to mitigate will only be successful if you can prove a discrete harm separate from the effects of the incident in question. So with that, I'm going to turn it back over to Brad.
And I'm going to continue my theme of talking about construction related to cases and statutes that affect them. This is a different kind of statute, a different kind of case, though. It actually deals with forum selection clauses. In this case, you had Sullivan, who hired a company called Rabco for a construction project in Noblesville. And the contract had a forum selection clause that provided that any litigation would be in Orange County, Florida. The case wouldn't be here if there wasn't a falling out between the parties. And so Sullivan eventually filed suit, but he did so in Hamilton County, Indiana. Rabko moved to dismiss, citing his forum selection clause, and Sullivan argued that it was unenforceable because there's an Indiana code section that says a provision in a contract for the improvement of real estate in Indiana is void if the provision, one, makes the contract subject to the laws of another state, or two, has a forum selection clause. The trial court agreed with Rabko, though, and dismissed the case. Sullivan appealed. And Rabko argued that the reason why the trial court's decision was correct here is this statute is part of the chapter of the code dealing with mechanics liens. And that if in a section of a code dealing with mechanics liens, the landowners shouldn't be able to use those statutes as a sword to defeat forum selection clauses, because those statutes are there for the contractor's benefit, not the landowners. But the court was not moved because of the way the statute was structured. And in this case, what the court said is, while the various sections dealing with mechanics liens all fall under Indiana Code Chapter 3228.3, they show that the legislature had the ability and forethought to use language limiting the various sections to the protection or enforcement of liens when they want that result. Because there are some sections that are around this particular section that specifically say these apply and reference liens. However, this particular section dealing with forum selection clauses and choice of law clauses does not reference liens or use any limiting language to apply to situations involving liens. And so even though it's within the chapter that's more broadly applicable to liens, this language does not. And so now in Indiana, if there's any contract dealing with improvement to an Indiana piece of property, then that contract needs to be litigated in Indiana, or can be litigated in Indiana under Indiana law, regardless of what that contract says. And so that is, I think, notable. That's something I didn't realize, and something that you may want to think about as you go forward. But now I'm going to get away from construction cases and deal with some other kinds of cases. And this next one is Hogan versus Magnolia Health Systems, which came out in December from the Indiana Court of Appeals, written by Judge Robb. And it deals with the question of the circumstances under which an employer could be liable under respondeat superior for what an employee does if the employee isn't liable. And so what happened in this case is you have Magnolia that runs an assisted living facility in Carmel, and Hogan lived there. And one day Hogan was at lunch, gonna get something to eat. An employee put something on a table, caused the table to fall over, and this eventually injured Hogan. Now, Hogan didn't know the name of the employee who caused the injury. And so when she filed her complaint, she identified the employee as a John Doe in the complaint. During discovery, Hogan sent interrogatories to Magnolia to identify the John Doe, but Magnolia said, well, we don't know who it was. But it did produce an incident report which identified a couple of employees who were involved. And one of those employees was Woods. And Woods had apparently placed items on a curio table, which caused the table to break. Well, after that, the trial court had a hearing, and the trial court ordered, Hogan, you need to identify this John Doe in the complaint. So Hogan did, and based on this identification, identified Woods. And in the meantime, Woods had changed her name. She apparently was married and is now Young. Young moved to dismiss being added to the complaint based on the statute of limitations, and the trial court granted that motion. And after Young was dismissed, Magnolia moved for summary judgment, saying, hey, we can't be liable as an employer if the employee's been dismissed from the case. And the trial court granted that motion too, and so that's what went up on appeal. And on appeal, the court didn't like Magnolia's theory at all. Well, it acknowledged that if an employee is not negligent, then the employer can't be liable for negligence under the theory of respondeat superior. But that negligence to negligence arrow didn't go for liability as well. And so a plaintiff could choose to sue the employer or the employee, doesn't have to choose both. And even if the employee was dismissed on a non-merits issue, like something with statute of limitations or something like that, that doesn't negate the employer's potential liability for respondeat superior for whatever kind of negligence the employee may have done. So there's a break there between employer liability and employee liability, and it all has to do with whether the decision against the employee was on the merits of the negligence or on some other grounds altogether, which I think is going to be important to analytically think about as you're going through these kinds of cases yourself. And then this last case I'm going to give you before I kick it back to Ron again is another case dealing with the interpretation of a statute. And this one is Henderson versus New Wineskin Ministries Corporation. And new to me, there is apparently some sections in the Indiana Code that define what kinds of duties non-profit religious organizations owe when people are on their premises for religious services. And they, when what the statute says is that when somebody enters a premises owned, operated, or controlled by a church, and is used primarily for worship services, that church only owes those people two obligations: one, to warn them of hidden dangers, and two, to refrain from intentionally harming them. That's it. And so in this case, you had Henderson, who attended the New Wineskin Church. She was driving there one morning for services. It was a snowy morning, about 2 inches of snow on the ground with additional snow falling. And she knew that the roads and parking lots would be slippery. Well, she arrived at the church, got out of her car, and after a couple steps, she slipped and fell and hurt her shoulder, back, and neck. Well, she sued New Wineskin for premises liability. And New Wineskin are moved for summary judgment, saying that, hey, this statute protects us. That danger was not hidden, and we certainly didn't intentionally hurt you. The trial court granted that motion. Henderson appealed, and her argument on appeal was that, well, this isn't the building that we're in. This is the parking lot I was in. The parking lot is not the premises that you enter into for worship services. That's the building that you do that, not the parking lot. And indeed, the very next section of the statute defines premises for the purposes of that statute to mean the building, not the surrounding grounds. But the court didn't buy that argument. Similar to the argument I talked about earlier, said that, well, if the legislature specifically defines a term for one section and not another, well, that probably means that doesn't apply to that other section. So we're not going to read those neighboring statutory sections to mean the same thing just because they're next to each other, use the same words. And then the court said that on another level, the court didn't understand why you wouldn't enter a parking lot. And the court said that it appears, while worship services were not conducted in the parking lot, that the parking lot was used primarily for worship services. And when the court then looked at the dictionary definition of premises, the dictionary definition includes both the building along with its grounds. And so for all of those reasons, the court said that for the purposes of this statute, which defines the duties that a church owes to people visiting, that those duties apply to both the building and the grounds surrounding the building. That all you have to do is harm about hidden dangers, and number two, not intentionally hurt people. So those are that was new to me again, and I thought it might be new to you as well. Ron?
Our next case raises issues regarding essentially what is the standard that the Supreme Court's going to, not the Supreme Court, but the appellate courts of Indiana are going to apply when summary judgment is being sought in the context of a premises liability claim. In Griffin versus Menard, there's a an accident that occurs when a customer comes in, pulls a box off the shelf at a Menards store, a box with a bathroom vanity sink in it. The staples apparently on the bottom of the box were loose. The sink fell through and injured Mr. Griffin. And suit was then brought for the injuries that he suffered in the store. Menard, first of all, argued that it had no knowledge of this problem, and therefore it had no duty to do anything about it. And the court, after considering all of the evidence, basically said, well, in a summary judgment context, which is how this issue arose, it's required that the defendant negate the duty element completely. And here, while there was kind of general evidence that the Menard had no knowledge of it, there was an issue with respect to notice, because there was evidence that the Menard employees were supposed to inspect these boxes before they're placed on the shelf. And there was, they may have said they didn't know about it, but they're supposed to know about it. And the court said, under these circumstances, we're not going to grant summary judgment on that theory. And also, the issue of res ipsa loquitur was brought into play. And the court basically said, and for those, by the way, who may not remember all of the elements, and we start this discussion in the handout by saying the tendency is try to get away from Latin words, but res ipsa is still with us. But res ipsa loquitur requires that or allows for inference of negligence when the injuring instrumentality is shown to be under the management or exclusive control of the defendant or his servants, and the accident is such that in the ordinary course of things does not happen if those who have management of the injuring instrumentality use proper care. And Menards basically argued this is not something that we had exclusive control of. This thing was boxed by Briggs Plumbing, and they filed a third-party complaint against them for the problems associated with the securing of the bottom of this box. But the Court of Appeals said that doesn't excuse Menards, that there is sufficient evidence here that it was on their shelves, placed there presumably by one of their employees, under their management, and we're not going to grant summary judgment given the state of this record. That's we're not going there. So a high bar in the context of a premises liability case before you can get summary judgment, either as to a res ipsa theory or to negate an element of a claim as to knowledge or awareness of the problem, when there's supposed to be an inspection before you place something on a shelf. The next case, Castleton Corner Owners Association, the Conrad Road, involves two issues, and I'll try to be brief because our time is expiring. But essentially, you've got an owner of a building, Conrad, a building that at the Castleton Corners shopping center, a retail shop. There's a malfunctioning of a sewer lift station, which leads to sewage in the store, and it basically closes as a result of it. And Conrad, as the owner of the store, loses rent during the current term of that lease. He's got he's got terms that allow for options to extend the lease, which he thinks are going to be extended, but for this problem. And he wants all of his damages from the association, the Castleton Corner Owners Association, which he says is responsible for making sure this doesn't happen. And the short answer is the court looks to the contract between the parties and says, yes, that the association is responsible for the continuous operation of the facility, and that they are responsible for all the costs necessary, essentially, to make sure that it's maintained properly. So the court says, yes, they're responsible under the contract, and basically finds liability for breach of contract against the association. Now, the trial court doesn't find negligence. And there's an argument, well, how can you have a breach of a duty? If you don't have negligence, how can you be liable under the contract? The court says, well, you don't have to prove that it's unreasonable or some of the other elements of negligence to prove a breach of contract. You've got a duty under the contract and you've breached it, you're liable for the damages caused. The fact that you didn't do anything unreasonable, it doesn't come into play when the issue is breach of contract. The other significant holding of this case, from my perspective, deals with the expert report. So there was a 263-page report by an appraisal expert, and it was offered into evidence during his testimony. The association objected on the grounds of hearsay, and the trial court overruled the objection and allowed the report to come into evidence. Now, most of the times when I've seen that happen in court, the court grants sustains the objection, saying, yes, the document itself is here, so you can testify to what his opinions are, but the document doesn't come in. In this instance, the court let in the document over the hearsay objection, and the Court of Appeals affirms, saying that that was an appropriate result under the circumstances. And I offer that to you. If you want to keep an expert report out or you want to keep one in, be aware that you've got a Court of Appeals opinion that says, and it uses some unusual reasoning in my experience. It relies in part on the fact that experts can, in fact, rely on the inadmissible evidence in offering their opinions. And here there was testimony essentially that this expert's opinions are set forth in this report, and there's hearsay is allowable. Can the report come in? Trial court said yes. Court of Appeals says yes. If you've got expert reports you'll want to be that you want to get into evidence or exclude from evidence, you want to pay some attention to this ruling in that regard. The final point deals with the lease extensions. The owner of the building certainly wanted to get lost rent for the lease extensions, and the court said there wasn't sufficient evidence here. Yes, there's a right to extend or an option to extend, but there wasn't evidence that the tenant was likely to exercise those extensions, and therefore they couldn't rely on damages for that loss. Back to you, Brad.
In the interest of being quick, I will be quick. Next case is Scholl versus Maj. It's a medical malpractice case resulting from a spinal surgery. What happened is a plaintiff's expert witness became a nightmare for the plaintiff's lawyer, I'm sure, saying that there's a mythical standard of care for doing spinal surgery. When asked what mythical meant, well, there's nothing you can specifically put your finger on. You figure it out by the seat of your pants. There's no such thing as a standard of care except what an individual doctor thinks it is. The defendant moves for judgment on the evidence. That's granted because he was unfamiliar with the standard of care. On appeal, court said, no, I think that's going too far. He at least showed that he was somewhat familiar with the legal standard for what constitutes the standard of care, medical malpractice. And he did testify about what a prudent spine surgeon would have done, and that's sufficient for the burden of proof. So while those kinds of comments may be imprecise, they do not necessarily show a lack of familiarity with the standard of care, and won't be a reason to keep an expert's testimony out or grant judgment to the defendant. The last case I'll talk about is Solomon versus Lindsay, deals with joint account owners. You had a dad who put money into a joint account for his daughter. It sat there for about 20 years. Eventually, dad's basically on its deathbed and has the new mom call with him to cancel the account. The bank issues a check the same day he dies. And so the issue is, who gets that money, the estate or the daughter? And the answer is the daughter, because there's a statute saying that when a joint account owner wants to make a change to the account like this, it's got to be in writing. This is just in a phone call, and so it's not good enough. Really interesting thing about it, though, is that in a footnote, the court cites another statute that was not argued by the parties or addressed by the trial court in support of the daughter's arguments. And it basically dealt with what the dad's intent really was. And for time purposes, I won't discuss it. But I think if you're dealing with these kinds of issues, I would look at that the court and the issue the court sua sponte raised in support of the daughter's decision. Ron?
Thank you, Brad. And I will be even briefer in addressing the final case, which is University of Notre Dame versus Bonney. And the primary lesson of that case is quite simply, you can be held to have committed misconduct as a lawyer if you know and learn that there has been a mistake in a false statement in a deposition by your client. And if you don't correct it after you learn of it, that the duty under Rule 26E to amend the discovery response applies not only to interrogatory answers, but to deposition testimony that you learn is mistaken. And in this instance, the court said there was misconduct because they learned of a mistake in the deposition and they didn't disclose it early. They disclosed it at trial. And the trial court suggested that that was misconduct that warranted a new trial. But the Court of Appeal said, no, it didn't satisfy Trial Rule 60b-3 because it didn't substantially prejudice the party's presentation of its case. But be aware that if you learn there's been mistakes in the discovery production by your client, you're going to need to correct that. Otherwise, you're going to violate Trial Rule 26E, which requires you to amend if you learn that. And the final, as usual, I end with an advocacy tip of the month, and I won't go into this except to say, Brian Garner has good ideas. His idea that is reflected here about giving essentially signposts in the form of headings and separating specific points with numbers and articulating that you've got not just several or just talking about it over a period of time, but giving a real map of what your arguments are will help you a lot in making your arguments more persuasive to the readers. I know that when I edit motions and briefs, that's one of the things I often do is create more signposts that clearly identify what it is that section is going to be about. And also, when you've got several things, identify them by number so that that can be clearly understood as well. With that, thank you all for coming today. I think we've got obviously another meeting next week, as Pete said, but it's been a pleasure and an honor to address you once more. And with that, unless Susie or somebody else has something to say, this will be adjourned. Thank you.